We understand, but still,
She, husband of the petitioner is a daily wage earner.
it's not that
She had not even obtained land from her father, my lord.
whatever be, but she has a land.
Her father had the land, my lord. She has not been given, my lord.
They could have come on time. Heard Mr. Z. Hamad, the counsel for the petitioner. Mr. G. Sharma, standing counsel for the FT matters, representing respond but 2, 3, and 6. And Ms. P. Barba, that's standing counsel for respond 4. And Mr. P. Sharma, an additional senior government advocate, appearing for respond 5. Page 69 is their opinion.
Correct. I'm not what's about letter issue, huh? What's about letter issue?
Here also there are 3 numbers. Opinion dated 28/8/2023, passed by so and so in so and so, arising out of Mr. Sharma, what is the case number?
Case number is, my lord.
FT 1394
1394 is the new number.
is the new number.
Yes,
Okay.
and the old number is 38, my lord.
And what is the first number?
First number is
MFT?
38, my lord.
Huh?
38 stroke 2012, my lord. That
No,
is the
no.
old-
What is the first number in page 69? 2023 of 2335. What is this?
Basically, a serial, my lord, that is maintained by the FT, my lord, or probably by police.
Huh?
Actually, the corresponding and the arising out of this particular case number, the last line, my lord,
Okay.
underline. DN case number 2725.
Okay. So this is unnecessary.
No, Lord,
This
the
is
original
answer.
case is DN case number 2725 of 98. This is
98.
original
That is
reference.
police.
What is the
Lordship.
first number?
Yes, Lordship,
MFT
reference.
J. What is this?
Then Lordship FTD 38 was
No. I am on the first number. I have come to
Yes,
second
first
number when I come to there.
Ekdam top.
What is the first number?
MFTJ 2023 of
What is this?
2335.
That we don't know.
Oh, damn.
That's really right.
Okay, here there are 3 numbers, huh? In so and so, old number so and so, arising out of DN case number so and so. By declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice extra copies within 2 days. Call for the records. Therefore, bail shall be considered on receipt of the tribunal records. So in the meanwhile, if the petitioner is apprehended, she shall not be deported without order of the court. After vacation, give a date. Make it returnable.
Can it be on 5th of January, but it's possible.
It will not come. Because 2 days will be taken for issue notice from here. Immediately it doesn't come. We'll give a date. It will be after view vacation.
Well, I'm deeply.
22/1/25. Wednesday.
22/1. Okay.
Max.
Item 3 and 4 for admission.
Lordship. This repetition was filed by the state lordship against the order passed by the FT
Yes.
Hailakandi lordship.
Yes.
And lordship flexi, there was a marked flexi lordship. And notice has been duly served lordship and in earlier order lordship. Oh, yes, lordship.
I'm responding number 4. Responding item number
But
4.
LCR is not yet received lordship. LCR is not available in the concerned foreigners tribunal lordship. I have sent a letter. Lordship, kindly allow me some time to verify. Lordship, otherwise Lordship may direct the Home Department to place this in Lordship. During filing of this writ petition, it was communicated to Home Department, Lordship.
Okay. This is item number 3.
3 and 4, same regarding LCR, Lordship, and notice has been duly served in both the cases.
No,
Lordship.
we are passing separate orders. These are the
Yes.
same proceeding or different people?
Different proceeding, Lordship.
Then we'll pass separate orders. In item 3. In item 3, you're not appearing?
No, no.
I heard Mr. G. Sharma, and that's standing counsel for the FT matters. I'm appearing for the state. As per order dated 27/6/2024. Just give a notice for AHMR Khan. As per order dated 27/6/2024, Mr. AHMR Chaudhary, AHMR Chaudhary. Learned counsel appeared for the sole respondent. Mr. Bhav, he's despite order dated 27/6/2024, his name is not reflected in the cause list. Next paragraph, the registry shall reflect the name of Mr. AHMR Chaudhary as counsel for the sole respondent while listing the matter next. Next paragraph. The learned standing counsel for the FT matters has submitted that despite his sincere effort, the records of
One is
FT
146 of 2012.
FT case number 146 of 2012 within bracket police inquiry number 42 of 2011. Which was decided by the Foreigners Tribunal Hailakandi could not be procured. Next paragraph, accordingly, the registry shall issue a requisition to the learned member, Foreigners Tribunal, Hailakandi, for transmitting the records.
Lordship, it is not available in the concerned tribunal, Lordship. They have already sent me a letter, Lordship, regarding that. Lordship may pass direction to the Home Department directly, Lordship.
No, but where is that communication is not available with us.
Yes, Lordship, I have that communication. But আপনাকে চিঠিখন দিল এই চিঠিখন যে দিছিল
Oh, this one, this letter.
Yes, Lordship, another is there, Lordship.
But this letter says in this connection, learned member Hailakandi has requested the deputy commissioner to return back the case records.
Yes, Lordship,
Then
Lordship. দাদা আৰু কেইখনমান দিছো উলিয়াই দিয়কচোন আৰু কেইখনমান দিছো আপোনাক উলিয়াই দিয়ক
you just quote this letter. Don't write the last line. Issue not shall issue requisition, not that. Say that the learned standing counsel for the FT matters has produced a copy of communication dated communication number HAF /4 2015 219 dated 4/2/2020 issued by the then Deputy Commissioner, Hailakandi, intimating to the Commissioner and Secretary to the Government of Assam comma, Home and Political, within bracket B Department, to return the records of FT case number 146 of 2012 and FT case number 148 of 2012. This 146 of 2012 within bracket police inquiry number 42 of 2011 and FT case number 148 of 2012 within bracket police inquiry number 44 of 2011. Where opinion dated 11/7/2014 and 26/10/2016 respectively was passed by the learned member, Foreigners Tribunal, Hailakandi. Full stop. The said letter also contains a reference that the said records were sent by the Deputy Commissioner vide letter number HAF full stop 4/2015/169 dated 13/1/2017 and HAF full stop 4/2015/174 dated 22/2017 for preferring just a stop respectively, full stop. Accordingly, the learned standing counsel for the FT matters shall communicate with the Commissioner Secretary to the Government of Assam, Home and Political, within bracket B Department, to produce the records of the said two FT cases before this court to his office. Next paragraph, the learned standing counsel for the FT matters shall communicate a downloaded copy of this order to the concerned authorities for the records. Next paragraph. List on due date at the end 29/1/2024 25. And in this second case, you record the name presence
It
of
was already mentioned in this order. That order will also cover this case also.
no.
It is FT case number
No,
148.
I'm passing a separate order. In the second item 4, you record the name of Mr. FKR Ahmed, then counsel for the respondent, sole respondent. And here the FT case number will be 148 of 2012 within bracket police inquiry number 44 of 2011. Rest of the order will be same.
Oh.
Common order creates a problem when I read the orders. It creates me some difficulty.
Item 6.
With major lordship. In this case, we want to withdraw our name from Ukalatnama lordship. And we take necessary steps as per Honorable Court order dated 16/7/2024 lordship. Lordship kindly pays office note dated 23/7/24, flag B. lordship.
Where is your notice you have sent for
It is
withdrawal?
flag B lordship.
Huh?
Office note kindly pays lordship office note dated 23/7/24.
Okay.
Did you make it? Hello.
Ms. Ardeka, learned counsel for the petitioner, has filed a letter dated 22/7/2024 addressed to the joint registrar within bracket judicial of this court, intimating that by a notice dated 18/6/2024, the petitioner was put to notice that of the intention of the counsel for the petitioners to withdraw wakalatnama. Stop. He said letter dated 18/6/2024 was sent by registered post with AD, which was posted on the same date. And as per contents of the letter dated 22/7/2024, it said letter dated 18/6/2024 was received by the petitioner. Stop. Is the provision of Rule 67 of Chapter 5 of the Guwahati High Court rules has been complied with. The counsel whose name appeared in the wakalatnama of wakalatnama. Discharged from further appearance in the matter. So their wakalatnama stands withdrawn. However, this said, wakalatnama shall remain on record for further reference, future reference. Next paragraph. All the respondents are represented. So for range of justice, the matter stands adjourned today. Next paragraph is the petitioner remains absent on call on the next date of listing. Appropriate orders will be passed on the next date. List after 4 weeks.
Item 7.
Yes, Mr. In this, there's a item 3. You have appeared. We are directing your name to be listed in the cause list. But please take note of this matter. Item 3. Correct?
Okay.
Mr. Sharma,
Lordship.
here the lawyer is D.K. Bakshi.
Yes, Lordship.
He is appearing in the matter now.
Earlier he is appearing, Lordship. Generally he is appearing, Lordship. Today,
He is appearing otherwise. Okay. Okay, there is no representation from the petitioner. How all the respondents are represented. So for end of justice, the matter stands adjourned today. So if the default persists on the next date of listing, adverse orders may follow. At least after 4 weeks.
Item 8.
May I please your lordship? Lordship, conducting counsel Mr. D.P. Bora is on lakes lordship. So the matter may be taken up after some time.
Okay. After some time.
Obliged lordship.
Item 9. Same order, none appears on call for the petitioner. Default persists. Same order. Okay, 9. Yes, Mr. Bhattacharya, your matter.
I appeared in this matter, my lord, and subsequently, because I had lost contact with the person, I'm paying for withdrawal of the wakalat. The application is that, office note will, is that, 9/8/24.
Your postal receipt, I can't even read.
Lordship can have the original.
Pass it on because I can't even read that. It's so light. You must remember I am going old.
We are all.
Eleven 8/21.
Lordship.
No, you'll have to give a fresh notice.
All.
21 is
In that
years
case-
back.
But my lord, at mention one of my friends came and said that a new council has been engaged.
Pardon me?
Another council came before the court, my lord, and mentioned that another council has been engaged by the party, my lord.
Is it?
At mention there was.
This is not recorded here.
No, no, no. Today he made that submission.
Today.
Today he made that submission. He was supposed to be here, my lord, but he's not.
Then we'll take it up after some time. It'll save you some trouble.
Hey.
Ah,
Sorry.
you're there?
It's a 9. Yes, my lord, we are newly.
You're appearing. Okay. Uh,
1 week.
Okay. Your name?
Yes, Islam.
S.
Islam.
Islam. You filed your Wakadama?
Yes, my lord, we have filed.
Okay.
Our name has been also recorded. here.
Recorded. Okay. Mr. S. Islam, learned counsel for the petitioner is present. You are doing the matter today or some other day?
Some other day, lordship.
Okay. The place for an adjournment, all the respondents are represented. Next para. Mr. D. Bhattacharya, learned counsel, who was earlier appearing for the petitioner is also present. As the respondent, as the petitioner has engaged a new set of counsel, the wakalatam of the earlier set of counsel for the petitioner stands discharged. Next para lists the matter after 4 weeks.
Obliged. Keep it.
It will quite.
Master please.
Item 16.
Lordship, my senior is out of station. Can they adjourn the matter for today?
Out of station.
Yes.
Okay, both sides are represented on the prayer made by learned counsel for the petitioner. Matter stands adjourned, please. This after ensuing due vacation. Item 18. No representation of petitioner. Petitioner remains absent. Adverse orders will follow. Twenty-one. Same order. 22. Same order. 23. Same order. 24. Same order. 25.
মাতা নাই, মাতিব, মাতিব।
25. Same order. 25. 26.
ছিলেন হ্যাঁ। Lordship, can it be at two lordship?
This matter.
Yes,
26.
lordship, yes.
Okay.
Yes. Top five to answer.
27.
Then do the full data.
Try to take up this also because prayer was made for upgradation.
Lord.
27. Right. 2 o'clock. Twenty-eight.
May I please your lordship? Basically, this is a mercy petition, lordship. After WS, he did not appear, lordship.
Oh, yes, yes.
And subsequently, he was arrested, lordship. Best document is 85 voters list, lordship, page 70, lordship, with my mother,
70.
70, lordship. Mother and father is there in 70 voters list. 66 of grandfather, father, grandmother. 70 voters list
Just a
of grandfather, father,
Just a
grandmother.
moment. This is that 85 document, which page?
Page 70, lordship.
70.
Yes, lordship.
Seven zero. Village is Borbala.
Yes, lordship.
Which is the next voter list?
Next is 97, lordship.
Same village.
Same village. 97, his name is not there in the certified copy. Reason is that he is marked as D voter. And 97 normal voters list also I have annexed, lordship. There his name is there.
Page 75.
Yes, lordship.
Where is his name?
His name is there at serial number 859. 859, lordship. 859, page 75, second column, 859, house number 309, lordship. Joinal. Shah Ali. Since
Joinal.
he's
What is the father's name?
Shah Ali.
Shah Ali.
Yes, lordship. Julas is there.
Ali.
Yes. Since his name is the voter, so certified copy, his name was not there.
He was arrested when?
Yes, Lordship, I didn't get.
When he was arrested?
He was arrested on 7/8, Lordship.
7/8.
Yes, Lordship. I have calculated till today is 133 days, Lordship.
Mr. Sharma will give an opportunity to the petitioner to, he's coming through legal aid.
No. No. Allow him to go on bail, Lordship,
Ah.
and matter may be heard on merit, Lordship. Allow him to go on bail, Lordship, and matter may be heard on
It's
merit,
ex parte after WS. No point, there's nothing here.
Lordship.
It will be nothing after written statement. His host says that he did not appear, contest the case. Practically an ex parte decision. By the time we call for the records and then examine and send it back,
Lordship.
we can do it now also. Conduct is not good, but still.
Lordship.
Which is that judgment which says that there's a burden on the petitioner if he does not appear before the tribunal. The court earlier had not interfered.
Yes,
Ex
Lordship.
parte orders,
Yes,
the
Lord.
High Court did not interfere.
Yes.
Where is that judgment? One is authored by Justice Manojit Bhuya. It was
Yes,
a very
Lordship.
good, very well written order.
Although fair and reasonable opportunities must be afforded to a proceedee to
Yes.
establish claim that he is citizen. However, such a grant of opportunity cannot be enlarged and endless exercise, Lordship.
Yes, yes.
Yes, Lordship. So many
Just-
decisions are there, Lordship.
No, we know that.
Lordship.
That's why we are asking, we are recording your submission.
Yes, Lordship.
Okay.
8361 of 2019.
Just please pass it on.
Yes,
Order.
Lordship.
Petition number तुम्हारा पहला
Comparison with
Totally.
हमें इस
Do you have a copy of this order? We are not getting it.
Lordship,
This Ijat Ali, you have a copy of that?
I am getting the.
Daji? Sajirul Nisa. कैसे आई है सच्ची 2009 heard Mrs. D. Ghosh, learned counsel for the petitioner. Also heard Mr. G. Sharma, that standing counsel for the FT matters, representing respondent numbers 2, 4, 6, and 7. And Ms.
And
N. Bedi, learned counsel, appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 3. And Mr. P. Sharma, additional senior government advocate, appearing for respondent number 5. There is no representation from respondent number 1. Next problem. By filing this CGC. SS Roy, okay. SS Roy, CGC, for respondent number 1. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex parte opinion dated 10/5/2023, passed by the learned page 27, passed by so and so in so and so. Opinion 10/5/23. By which the petition was declared to be a follower of post 25/1971. No, this is not an ex parte.
Not expert. He has filed his written statement. Thereafter, he did not appear.
No, he appeared. His evidence is recorded. His evidence is found to be recorded.
But again, repeatedly.
I see Dada.
He did not come for cross-examination, I think.
Yes, cross-exam. But
But then he would not get an opportunity.
I have annexed. He has, I have annexed also, yes, I apologize, Lordship, I have annexed his evidence on affidavit, page 61.
Then
And
we'll have to,
thereafter, he did not appear.
then we'll have to call for the records and examine it because
I have
Then-
annexed the DW1, Lordship.
no, because
Page
then
61.
this Ijat Ali would apply. Because then we can't take a view different from this Ijat Ali.
Yes. He has filed his evidence on chief,
But then
page
after the,
61.
so
And
now we'll have to
thereafter,
call for the records. We'll have to examine it.
is by order dated 14/11, his record was called for, Lordship.
Yes, yes.
Thank you.
Record has not been received.
Yes,
So
Lordship.
issue a reminder for that. Mrs. D. Ghosh, legal aid counsel for the petitioner is present. All the respondents are represented. Next, the reports which were called for by order dated 14/11/2024 is not yet received. This from the registry shall issue a fresh reminder by email for the records at the following email address of the Foreigners Tribunal number 6th, Borpeta. You give this email address. Okay. So the bail for bail
Will be released on
will
bail.
be renewed on receipt of records of the tribunal.
He may be enlarged on bail at this.
We'll have to
stage.
go, we'll see the records. We'll fix a date, short date for you.
Yes, Lordship.
Make it 10th of January.
Then I have annexed even the inquiry report, there is no allegation against it. Page 46, Lordship.
No, we understand, but still
We
we'll
have
to.
annexed, I have annexed because there is no allegation. And there is Honorable High Court's order also, Lordship, in WPC 1216/2019 and also in Indira Nevari. There is no allegation that he is from the specified territory, Lordship. At least at this stage, he may be enlarged on bail and let the records come and then Lordships may decide on merit. Otherwise, I have a very good case, Lordship, only because of his poverty, Lordship.
Where is the inquiry?
Inquiry page 46, Lordship.
6.
And relevant portion, page 48, Lordship. Whether migrated into Assam? No. Inquiry officer said no, he has not migrated in the state of Assam. And there is no shifting from 66 onwards, same village. And even
Inquiry was done by ERO Lordship.
and ERO Lordship
This is the report of LV Lordship.
and ERO also said annexure 6.
Reference depends on the satisfaction of ERO Lordship.
May I complete my submission, Lordship? Page 49 is the ERO's report. ERO says that based on what is annexure A, local verification officer's report. And local verification officer's report, on the other hand, says that he has not migrated in the state of Assam from the specified territory. If he would have migrated from the specified territory after post 1971, it would have been clearly mentioned in the inquiry report. And the ERO's report is based on LBO's report. And there are lots of judgment
Let
of
the
this.
records come, Lordship. All things are not legible in the copy, Lordship. Something must retain.
I have the certified copy which was being provided to me by the High Court Legal Service Authority. I have the original certified copy. That's in the Colorado inquiry report. Certified copy inquiry report. Yes, these are the inquiry reports. Without the other copies. That's basically how original certified copy. I have.
কি লিখা আছে এখানে?
Actually, I could find it. No, whether migrated is clear.
Bring to that judgment, please. pass it
Yes,
on.
Lordship. WPC 1216/2019. Lordship.
Wait. Yes, I said. Last para. The London Legal Aid Council has paid for, you filed an IA for bail? No.
Yes, Lordship. Yes, Lordship. IA number.
IA? This was also for records. Huh? We enclose this. It is an IA.
Three, four, eight, seven.
Very good. That's also of the council. Next, for the London Council for the Legal Aid Council has renamed the prayer for seeking release of the of the applicant from the detention camp, Mathia, Gwalpara, where he is detained since 7/8/2024. Pursuant to opinion dated
Dated 10/5/2023.
10/5/2023, passed by the learned member, Foreigners Tribunal number 6th, Barpeta in FT case number 56 of 2018. Next, prayer for bail is opposed by the learned Standing Council for the FT matters on the ground that although the applicant had opportunity of proving his case, but he did not appear for his cross-examination. And therefore, having been declared as a foreigner, the petitioner is not entitled to be released on bail. Next paragraph. We take note of the fact that the petitioner was arrested on 7/8/2024 and till date, he has suffered custody for 133 days. Under such circumstances, the court is inclined to release the petitioner on bail on the following conditions. Those three conditions will be there. Number one, for the family members of the petitioner shall appear before the Superintendent of Police within bracket border Barpeta and shall furnish a bail bond of rupees 5,000 with one surety of like amount to the satisfaction of the said authority within 3 days. So procure and then all those two conditions. Next, as a condition for grant of bail, the petitioner is directed not to leave the jurisdiction of the Superintendent of Police within bracket border of Barpeta without prior written intimation, failing which it will be open to the said authority to move this court for cancellation of bail. Next, interlock the after assistance disposed of, allowed and disposed of. We give this back. Giving our judgment back. It's been- Hmm? No, we'll complete it then. we'll call. Yes, 29.
Deeply obliged, Lordship.
May I please your lordship? But of the matter we adjourned for the day, my senior is out of station today.
Okay, which I represent, the prayer made by Council for the pedestrian, it's John today. List of tenants in vacation. Okay, here the records have come, no,
Yes, Lordship.
has been received.
Yes.
Just record the pursuant to order dated 22/11/2023, comma, the records of the traveling is received. Okay,
Bless my Lord.
30,
My lord, here in this case, my lord, the petitioner was arrested on 2/9/24, my lord. And
Two-
now detention camp Matiang, Golgotha,
2/9/24.
2/9/24.
How
My
many
lord.
days today?
My lord, more than 3 months, my lord. 2/9. 4 months.
What is the best document you have?
My lord, the decision is ex parte
Yes.
and the Inkun order says that I left the village and the notice was hanged on the notice board of the Gaubura. And whereas I am all along Bhutar in the same village with my mother, and mother is also Bhutar with her parents. My lord, in 66 Bhutalist Annexer 3, A. Jalil is my father. 70 Bhutalist also. But here in this case, my lord, my mother was deserted my father after delivery, after of my birth, my lord. So my mother then started to live with her parents. My lord, in 66 Bhutar list, my mother's father, parents are Bhutar. Then my mother is also Bhutar with my maternal grandparents. '75 Bhutar list, my mother is Bhutar with my grandparents. My mother's name is Kotban at piece 75 Bhutar list, piece 35. Then my lord, in the subsequent Bhutar
The
list,
village is same,
my lord, yes, Gonakpara.
Konakpara.
Gonakpara.
No. Yeah, I have part.
Your mother is Katbhanu.
Kotbana. And my maternal grandparents are Manik Mir and Maziran Nesa. They are Bhutar in 1966-70.
So, but you'll have to carry your legacy through your parents, own
Yes.
parents.
Yes, my lord. My father is Bhutar in different village because my mother had to. My mother was deserted my father, so my mother immediately after delivery of after my birth, my mother started to reside with her parents' house. My father is also in 66 onwards, Bhutar, my lord, in different village, Dhakayapara, in the Bobata PS. So linkage in both way is there, my lord. From my maternal side, my paternal side. Father is still alive, and he is also ready to adduce evidence on my behalf. I have contacted with my father also.
From inside jail, you could,
My lord.
from inside jail, you could catch your father.
My lord, my other family members are there, my lord. They have contacted, my lord. Through people, my lord. Through my people, my lord.
Okay. Yes, what to do?
Let him go back, lordship.
To the tribunal.
If lordship willing to examine the record, then the record may be called for.
My lord, he may be allowed to go on bail.
Otherwise, lordship may allow to go on bail, lordship, and
Records has not been received. We'll
Yes.
allow him to go on bail then.
yes, lordship.
Then we'll consider. Okay, heard Mr. A.R. Sigdar, learned counsel for the petitioner. Also heard Mr. S.S. Roy, learned CGC appearing for respondent number 1. And Mr. G. Sharma, learned study counsel for FT matters. Representing respondent numbers 2, 4, and 6. And Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 3, and Ms. P. Barwa, learned standing counsel for respondent number 5. Next one. The by order dated 4/12/2024, the court has had called for the records from the learned tribunal. Stop. As per office note dated 13/12/2024, LCR, the tribunal records is not yet received. Next, the learned counsel for the petitioner has renewed the prayer for bail on the ground that the petitioner was apprehended on 2/9/2024 and is currently lodged in the transit camp, Matia, Gwalpara. Next para. The prayer for bail is opposed by the learned standing counsel for the FT matters. Next para. Taken into consideration that the petitioner has spent more than 3 months in custody in custody in the transit camp, Matia, Gwalpara. The court is inclined to release the petitioner, namely so and so, on bail on the following conditions. The 3 conditions that petitioner shall, family members of the petitioner shall appear before the Superintendent of Police, Border, Borpeta, of a bail of ₹5,000 with one surety of like amount to the satisfaction of the said authority. All those 3 conditions are there. Then, as a condition of bail, it is provided that the petitioner shall not leave the jurisdiction of Superintendent of Police, Border, Borpeta. Next paragraph. Registry shall issue a fresh reminder for the records from the tribunal. Next paragraph, list after 4 weeks on a date to be fixed by the registry.
Deeply obliged, lordship.
Oh, this will be an IA.
I may be disposed of.
IA disposal. $31.
It should kindly pass over for the time being.
Time being.
My senior is in court 3.
Okay, time being. 32. 32, Mr. Ahmed, it's your matter. You're not.
34.
32.
32 is not yours.
Oh, yes, yes.
I think 34. The matter may be taken up after deepening the vacation.
After vacation. After vacation, 32.
But 34 বলে ভাবি তো?
34.
Okay.
34.
Huh?
34.
Okay, it's over. Okay, I did not mark it. 35.
May plead your lordship. As per office note dated 12/12/24, the service is not complete.
Lordship, we have received one ministerial inquiry report we have received today. Lordship, we have received that. এমনি affidavit তো ফেলতে বলা হবে, এই তো দিয়ে দিস, হ্যাঁ,
Okay.
But the affidavit from the SP is on the, also on the, we will file it by today.
By today.
By today, we will file.
Okay.
And this report, possibly within 10 days or week, they will.
It will come. Listing it on 10th
Yeah.
of January. 10th will be the last date. No,
Maybe on 8th.
make it 8th,
8th.
next date. Miss
F. Hussain.
F. Hussain, the counsel for the petitioner is present. Mr. D. Nath, the senior government advocate. Appearing for the state respondent. Numbers 1 to 7
1 to 7.
has produced a copy of written instructions dated 16/12/2024, indicating that the ministerial inquiry is nearing completion. Stop. In view of the matter stands adjourned today, so as to enable the learned senior government advocate to bring on record the report of the ministerial inquiry. Next paragraph. As per office note dated 12/12/2024, comma, notice on respondent numbers 9 and 10 is still awaited. Next paragraph. The registry shall send a notice to the respondent numbers 9 and 10 to appear either in person or through their counsel on 8/1/2024, 25. Most of the a downloaded copy of this order shall be transmitted through the VHF facility available in the High Court. To the Bokata, 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 Nemuguri, Nemuguri police station. For onward service to respondent number 9 and 10. So this mode of service is in addition to the postal steps already taken by the petitioner. Next para, the affidavit of the respondents shall also be filed at least 1 day prior to the next date of listing.
Malik.
List on 8/1/2025. And this- Before that, you write a copy of this written instruction. They're on the various state that he has produced this, so that the same is made a part of record.
Okay.
Deeply obliged, Your Lordship.
Speaking to accurate, this, no? This spelling of the police station is right. Bokota,
Bokota.
correct.
Yes.
Spelling is correct.
Yes.
Okay. We'll take a short break and come back.
Spelling to Bokata. নাই দেখো
But another advocate could not stay there. But his another advocate is also not taken step.
So definitely he's withdrawn the Vakalatnama. You see, after 6/3, next date, what is the next date? On that day, he files a petition for withdrawal of Vakalatnama. It's allowed, I think.
Actually, what happened was
4/5/21.
Huh?
6/3/21.
After 6/3, next order.
4/5/21.
On that
Then
day,
neither proceeding nor engage counsel.
no, after
appeared.
that, there's another order. He withdraws Vakalatnama. Or is it 6/3 only?
Yes, Lordship.
6/3, he withdraws the Vakalatnama.
Yes, Lord.
Correct.
6/3, yes.
Ah.
On the same day.
Lordship. At the relevant period
No,
of
no,
time,
don't
Lordship, it
don't
was
make
very
stories.
tough, Lordship, for
Don't make
communication.
stories which is contrary to the petition on the record. You have to bring whatever you want to say, you have to bring it on record. Because here he has withdrawn it.
Yes, Lordship.
So your oral explanation will not be a good explanation.
Lordship, kindly give a last chance, Lordship, a last chance, Lordship, watching to file a written
No,
statement.
but you see, no, you see, we have no difficulty in allowing the prayer, but it must match with the case record. You will have to bring on record an affidavit. Because once he has withdrawn, then the other part of the story will fail. And if you don't adhere to the principles of pleading, then it will lead to dangerous consequences.
Yes.
Anything can be written in the petition and anything can be argued. That may not be an appropriate manner to deal with writ petition. Bring it on record. Bring the correct statement on record. We are not adverse to grant you bail, but the story must match. Otherwise, it will be inconsistent pleading. It will not be healthy. You have to bring it on record. Bring the correct statement on record. You look at the order sheet, go through it and bring it on record. We are not averse to grant bail. But the story must match. Otherwise, it will lead to dangerous consequences. In one case, if we accept it, then the second case also will have to accept that lead to different consequences. Both sides are represented. Next, the learned counsel for the petitioner. After going through the trial court records of the tribunal, praised for his and is granted an opportunity to bring additional facts on record by way of an affidavit. List when?
In a short time, Lordship.
Tell us, we'll give you that day. When?
Within
1 week lordship, I can find.
List on 3/1/2025. Yes.
Standing
31.
item 31.
Here is your lordship.
Yes,
This review petition is against the order dated 5/8/19 lordship in past state WPC 4/19 by this.
5/8,
Lordship,
which-
which matter, lordship, LCR has not been received.
not received. That says not come.
Lordship,
We have the
I
replacement.
think LCR, I think it is available lordship with me.
It's available.
Yes, sir.
2021, right? Yes, lordship. বঙাইগাঁও ন? বঙাইগাঁও নেকি?
You've gone through it?
Lordship, I have not gone to
No,
actually.
because then you'll have to address us.
Yes, lordship.
You are on interim protection?
Only lordship, the honorable court should have taken into consideration that a paternal cousin brother Habibur Rahman was declared Indian by FT Bongaigaon case number 198/07. And lordship, the NRC data submitted along with this review petition page 29 and 30 may be taken
No,
into
this,
consideration.
no, you, please come to
Because-
page 29.
Page
Please.
29 and 30.
Please come to page
But
29.
in case with the father is reflected. Page 29.
Yes. Is your cousin brother reflected here?
Lordship, at that time, lordship was just unable to produce. this
No,
thing.
no. This name of your cousin brother,
Yes.
is it there in your written statement? Well, I did not find it. Then,
Because at that particular point of time, we could not produce the NRC linkage certificate.
no, that is okay, but your brother was there.
Yes, no, linkage certificate after that is got lordship.
No, no. You don't confuse us. By nature, I am a confused man. You see, what I'm trying to ask you, when you filed your written statement, you had a father, your father had a brother,
Yes,
and that brother, father's brother had a son.
yes, lordship,
Is those things reflected in your written statement?
yes.
No. Because I did not find it.
Yes,
I might have missed it. Because as per the,
Lordship, at that, when the,
you see, because we are coming from this, we are borrowing it from
that
the case of Sarvanand
our
Sonwar.
cousin brother, that is Habibur Rahman, lordship, at particular point of time when the WS was filed, we could not submit any documents, lordship.
It's not a question of document. Have you introduced him? You see, we are time and again reminded by Mr. Sharma about paragraph 26 of Sarvanand Sonwar. Every day, at least 2 times, he reminds us of paragraph 26 of Sarvanand Sonwar. There it says that these things, facts must be pleaded. Because you are asking us, you are invoking the jurisdiction of review.
Yes, sir.
In a review, you'll have to show us that some evidence was left out or the other parameters of review are applicable. Because if you have not pleaded that in your written statement, how can that be a ground of review? Because in review, we cannot take note of new facts unless you demonstrate that despite due diligence, those could not be brought on record. But after paragraph 26 of Sarvanand Sonwar, how will you convince the court that this was inadvertently left out because Sarvanan Sonowal says all these facts must be pleaded, and therefore it says burden under section 9 is on the proceedee. How do you overcome that barrier?
Another date may be given, I'll go through it, Lordship.
Lordship may keep the record in the custody of the court.
We will
Lordship.
keep it.
Yes, Lordship, I will save from the court. Lordship.
Both sides are represented on the prayer made by learned counsel for the petitioner. The matter stands adjourned today. Next para. Mr. G. Sharma, the standing counsel for the FT matters, has submitted that he is in receipt of the records of BNGN oblique FT oblique case number 1758/08, which was in which opinion dated 2/9/2019 was passed by the Learned Foreigners Tribunal, Bongaigaon number 2, Bhayapuri. Full stop. Just show them. So the said record. Twenty-9th of January 2025. We're giving a fixed date. Madam.
Timing item 26.
May please, Your Worship. Here I have silenced the order dated 27/9/2018, by which the petition has been declared to be a foreigner, and pursuant to that order, my lord, he has been taken into custody on 7/8/2024, my lord. And as of now, my lord, 133 days he is in the detention.
Yes, we are proposing to hear the matter on merit. That is why on the last date, the matter was adjourned.
Yes.
You say that you have a brother, Saadat Khan.
Yes, my lord.
DWT was recorded as not a. Where is that document? In your written statement, have you introduced Saadat Khan?
No, my lord. Written statement is written drafted by an advocate, my lord, very casually, my lord.
Where is the evidence of this Saadat Khan DW3?
Yes, my lord. Page 78, my lord. $78 is the cross examination of BW3.
Page number
78. Right.
70. There's no voter list of you along with your brother,
Yes, my lord. Kindly see page my lord, 30, my lord.
30.
301. Type copy, my lord. Voter serial number, my lord. 463, my lord.
No, this is
463.
not an exhibited document.
Yes, because, my lord, in 1997, my lord, the petitioner has been marked as a D voter, my lord. Because of that, my lord, certified copy of the voter list could not be obtained. That is why, my lord, page 30, my lord,
This is a document which is
463, my
not,
lord, Rajab Khan is the father of the
but
petitioner.
this is a document not exhibited.
Aros Khan, my lord, 465.
This
the
was
petitioner.
never exhibited by you.
Yes, my lord. As because, my lord, as the D has been marked against his name, my lord. So,
That
my lord,
explanation
certified
is,
copy of the voter list could not be
no,
obtained.
no,
my
that
lord.
explanation is something else.
Yes,
Even if,
Till date, my lord, certified copy has not been issued by the.
no,
office,
even
my
if it
lord.
is not available, but you could have called the electoral officer and proved this document. This you did not do. You did not, you don't introduce your brother. DW2 does not introduce the brother. And this brother suddenly comes and says that I am his brother.
Yes, my lord. Evidence in support that has been.
You have not proved it. You have not even said that there was a tribunal opinion in favor of your brother. These things were not even pleaded.
Yes, my lord. The voter list, my lord, right from 1997, my lord, till date, my lord, his name is along with the petition, my lord. Shadat Khan's name, my lord. This is page 31, my lord, 467, my lord, Shadat Khan. The same voter list in the same house number, my lord, along with their parents, my lord. 463, Rajab Khan is the father of the petitioner. 465, Aros Khan, the present petitioner, and 467, Shahadat Khan, the DW3. my lord. Only because of D, my lord, that document would not be proved, my lord. And 2005 also, my lord.
Mr. Sharma,
Lordship,
the documents at page 42 appears to be matching with this record. We granting bail to the petitioner then. Page 42 is the opinion of the brother. The documents available in the record is matching.
Same, no, only same. Document.
We give bail.
Lordship.
And the other records have not come. You filed an IA?
No, man.
Our opinion is very much elaborate, Lordship. Opinion is,
Hmm?
I think Lordship, opinion is very much elaborate and discuss all these things, Lordship.
No, but
and-
once there is a brother declared to be
Yes.
a foreigner, we have to rethink.
Yes, Lordship.
It has to go back.
Lordship, may I allow him to go on bail, Lordship.
Hmm? Yeah,
Bail may be considered, Lordship, and
we're granting bail.
for further hearing, Lordship.
But Mr. Islam, Learned Counsel for the petitioner, also heard Mr. S.S. Roy, Learned CGC appearing for response number 1, Ms. P. Barwa, Learned Standing Counsel for response number 2, Mr. G. Sharma, Learned Standing Counsel for the FT matters representing response numbers 3, 4, and 6, and Mr. P. Sharma, Learned Additional Senior Government Advocate for response number 5. Next, the Learned Counsel for the petitioner has submitted that the petitioner was apprehended on 7/8/2024 and is now lodged in transit camp called Matia Kualpara. Just accordingly, prayer for bail is made. Stop. Next, the prayer for bail is opposed by the Learned Standing Counsel for the FT matters. Next, in this writ petition, it is projected that a DW3, namely Sahadat SHAHADAT, Sahadat Khan, who was the proceedee in FT case number 270 of 2015, arising out of IMDT case number 36/2014, was declared to be not a foreigner by the learned member, Foreigners Tribunal 6th, Barpeta, by opinion dated 1/12/2016. This is page 41. Stop. It is submitted that on the same set of documents, the petitioner Araj Khan, ARAJ KHAN, was declared to be a foreigner. Next para. In light of the opinion dated 1/12/2016, in FT case number 270 of 2015, against Sahadat SHAHADOT Khan, the projected brother of the petitioner, court is inclined to release the petitioner, namely Araj Khan, on the following conditions. The three conditions, take it from them. There'll be three conditions. The family members of the petitioner shall appear before the Superintendent of Police within bracket border, Borpeta.
All the family members, madam?
Huh?
All the family members.
No. Some family member have to go and furnish bail.
Yes.
The conditions are within 3 days, you'll get the petitioner into the custody, take iris and hands. Those conditions will be there. Next, as a condition for bail, it is provided that the petitioner shall not leave the jurisdiction of Superintendent of Police Borpeta without written intimation to the said authority. Next para. By an order dated 26/9/2024, this court had directed the registry to call for the records of FT case number 270 of 2015 within bracket State of Assam versus Sahadat Khan, decided by opinion dated 1/12/2016. First of it appears that the said records is not yet received. Next, but accordingly, the registry shall issue a fresh requisition for the said records. Stop. Next, it may be stated that the records relating to the present case is received. Next paragraph. List after 4 weeks. Awaiting receipt of the records of the FT case number 270 of 2015 from the Foreigners Tribunal number 6th, Borpeta. Next list after 4 weeks.
By your blessing.
Yes.
Time being item 8.
May I please the lordship? Lordship, impugned judgment and order dated 29/8/2017 is at page 30. 30 and 30 to 32, lordship.
Yes. Yes. Where is your written statement?
So that is not annexed here, lordship.
Not annexed. You okay? You continue post lunch then. You've seen the record?
No, lordship. Otherwise, lordship may fix it immediately after vacation. Lordship.
No, this will be I think this will be a short matter. If you can just find the written statement. You see, in this writ petition, you are projecting that you have some relation with the person in whose opinion, for whom opinions were rendered in page 25.
Yes, lordship.
Correct.
Yes, lordship.
The person at page 25, Arun Seal,
Yes, Lordship.
He is not there in your written statement.
Yes,
He
Lordship.
did not come and he did not introduce this brother, this man, Arun Seal. Who is Arun Seal?
Arunshil is the brother of the petitioner, Lordship.
But he was never introduced. Did he come and depose in your favor? I don't think so. And this is an opinion of
13.
28/1/2013. Which is prior to this. We don't find anything here to support you.
Lordship, otherwise also my father name
We
is,
continue at 2 o'clock. You go through the records. No,
Yes,
just
sir.
by father, it doesn't prove
Yes, sir.
that this Arun Seal is something related to you. You're not introduced him. How do you sustain that part of submission? You continue at 2.
Lordship, item 31, Lordship, I handed over the record to the court, Lordship, that was reflected or not, I have not
You
listened,
recorded
Lordship.
it.
Yes, Lordship.
You recorded 60
That
pages.
maybe,
You have also recorded 60 pages.
yes, Lordship.
And this record could not have been with you. You know why?
Lordship.
Because this, you look at the file. This record was sent by the tribunal to the registry of this court.
Yes, yes.
How did it
Lordship.
come to you?
Yes, Lordship. Perhaps a court has
No, we don't know
directed to see
because
the record and
after requisition, today is the date when it's
I'm
come
praying
to
for-
court.
retaining the record, Lordship, something that like
No, but
happened,
it should
Lordship.
not have gone to you in the
Yes.
first place.
Lordship.
Because there is no order to hand you over the record.
Yes, Lordship.
Ah.
Lordship.
Now it has come, Lordship, in our file, Lordship. Office.
No, that's okay. We got the record, but
Yes, Lordship.
it would have led to some consequences because of the fact that it was sent by the tribunal to the registry.
Yes, Lordship.
No, when I am handling the records, I see everything.
Lordship, I have one more submission, Lordship. Lordship,
That's 2 questions.
can this matter be listed on any other day? Because at 2, the conducting officer, Mr. DP Bora, have another matter in court number 2, Lordship, fixed. So,
Okay, both sides are represented on the prayer made by the counsel for the petitioner. Matter stands adjourned today. This after NC winter vacation. Okay.
deeply obliged, Lordship.
Huh? হেৰি আৰু নাই নেকি কেছ নাই নেকি আৰু হা কেছ নাই নেকি হৈ গ'ল আৰু মই অকল ইনচেকশ্যনটো এইটো আমাৰ এই মানিকুদ্দিন বৰভূঞা আৰু হেৰিটো হোম ডিপাৰ্টমেণ্টলৈ আকৌ খবৰ ল'ব লাগিব এই কেছটো কিয় ৰেকৰ্ডটো দিয়া নাই তেওঁলোকে এই ট্ৰাইব্যুনেলত নাই এইটো এপিল ফাইল কৰোঁতে আপোনাৰ হোম ডিপাৰ্টমেণ্টলৈ পঠিয়াইছিল হোম ডিপাৰ্টমেণ্টে স্ক্ৰিনিং কমিটিলৈ পঠিয়াইছিল এতিয়া তাৰপিছত তেওঁলোকেও নাজানে ৰেকৰ্ড ক'ত আছে গতিকে কমিশনাৰকে কৈ পেলাই ৰেকৰ্ডটো উলিয়াব লাগিব ক'ত আছে এইটো 3 আৰু 4 29ত আহিব 29 জানুৱাৰী নাই ইণ্ডিয়ান ডিক্লেয়াৰ কৰিছিলে আমি এপ্ৰিল কৰিছো ই বেগটো পালে Shahidul. Shahidul Rahman. Check out the pitch. টিভি খতম হয় আজি
মানে পিয়ার্স মানে আজি বহুত দিন নাই এটা
বহুত উঠি নাই
জুসটো পাই
And Upadhyay, I'm standing counsel for the irrigation department, are present. Full stop. Pursuant to no, next, the learned standing counsel for the irrigation department has produced a copy of letter dated 16/12/2024 by the
ডেপুটি সেক্রেটারি লস
Deputy Secretary within bracket E, bracket close to the Government of Assam, comma, Irrigation Department, comma, addressed to the Secretary, comma, APSC. This said letter is made a part of record. Full stop. The you have given Mr.
copy,
Mundra
yes,
huh? Full stop. Copy of the same is provided to Mr. TN and TJ Mohanty, Learned Senior Counsel, assisted by Ms. P. Sharma, Learned Counsel. Who was submitted that he has not yet received any instructions. Next paragraph. In view of the contents of the said letter dated 16/12/2024, court is inclined to adjourn the matter. Full stop. List on when
8 minor.
8
January.
8/1/2024. 25.
Well, 25.
Lordship.
Development.
Obliged, Lordship.
But Mr. Upadhyay, be prepared. There's 2-3 queries which I had.
Lordship.
Even on that day, even if all of you agree, still those questions will remain to be answered. Be prepared on that.
Minor.
Lordship.
Correct.
Item 2.
Yes, Dibru Dangri.
Made legal of.
Yes.
Essentially, it was a compliance or non-compliance of section 43, subsection 8, which had gained prominence during the initial round. Thereafter, we had moved the writ appeal below. In that writ appeal, we had, of course, annexed documents to show compliance. However, as rightly pointed out by my colleague, that was not a part of the reports here, though. Accordingly, annexing them, we had prayed for review of the matter. If that is compliance, yes, if that is no. And now, those are at page 29 and 31. That would be substantive compliance, my lord.
Yes, we remember it.
If my lord recalls, I do not read it any further. And 31 is the official communication. Intra-official. And they would do, and they do not deny it till then. Till now. About our prayer, and that being well ahead in point of time. The only thing is that would my lord be pleased to construe it as a compliance of 43A? If that is so, then we go ahead for the AG. I mean, that should be approved.
That means you'll have a right of re-election.
Our proceeding should be approved. Disapproved on the count of this, when we challenged, this came through. And 43.8 is not binding on them. It gives them a relaxation. They may or they may not.
Come to the judgment.
25. Relevant part is my lord referring to. 25 minutes.
Lordship, 24 is pertinent, your lordship.
24.
24E, your lordship. Because there was a hearing was conducted, there was a hearing report, as well as a letter from the ARCS Tinsukia cancelling
No. Page number.
page number 24 of the review petition, your lordship. Review
24, yes.
Yes.
If your lordship will see at the last paragraph, E, on specific query of the court.
No, that is page 25.
25. 25.
In my page, it is 24. 5.
Okay.
One was
E.
I'm
withdrawn.
reading that-
One review was withdrawn, you know.
E,
Perhaps
yes.
See, your lordship, on a specific query of the court, it could not be brought to the notice of the court that any of the litigating parties herein have assailed the finding of the ARCS Tinsukia in answer number 2, query of the issue number 8 of the hearing report and findings of the ARCS Tinsukia, which is appended to communication dated 29/9/23 by ARCS Tinsukia. Thus, the said part of the finding has attained finality. So in 6243 in the writ petition, your lordship, there was a finding from the ARCS Tinsukia that one, your lordship, that the quorum was not there on 14/9 when the executive meeting held. Secondly, your lordship, in regard to that since the government nominee was not informed, the government was not informed regarding the AGM. Now, this inquiry report was never challenged by the petitioner, as well as the letter which ARCS declining the executive meeting, your lordship, that was not challenged. Now, subsequently, now they have produced these documents. If they had this document, this letter, which was sent 3 months prior to the AGM, they could have placed those documents when subsequent to the finding or challenged that finding of the ARCS, which was never, it was never challenged in 6243, your lordship. So that's why your lordship has said that it has attained finality. Therefore, in view of the discussion about the holding of
No, but
AGM,
if such a document is there,
lordship,
supposing there's a document which is contrary to this E
Lordship,
of paragraph 6,
Lordship.
then what happens?
Now, there was a request to install a nominee, your lordship, that was 3 months prior. But here, your lordship,
It would start from A, but regardless of anything, Minor.
it start from
The
A.
only
your
issue
lordship.
was whether
No,
we had.
no, just try, let me recapitulate in my way.
Yes,
You see, one of the finding is that the society did not notify ARCS of there being a AGM, right? The same was required because of the fact that there is a requirement under law to have a nominee of the government, where there is any shareholding of the government.
We had the answer to that, Minor. With all respect, it was the AGM who put to notice to go ahead and hold the election. It was the, I'm sorry, it was the ARCS who had put us to notice that go ahead and hold the election. The clearance from them came and therefore went ahead. The mandate of 38 is not shall, it's may. They may not. That's up to them. But to hold it against us, we had just produced a document. They are not objecting to it, whether it merits consideration until 43.8 Miller. That's what. May I read 43.8 for a moment? What it actually says.
43.8 is quoted in the order also.
Yes, sure.
And this is not even opposed by the other side, the third group, the other group. And what is more interesting is that the department is not in denial of it. Rather, they have acted in furtherance of it.
Some cooperative societies. Hang on. This C is becoming C. 40 biology, section 30, 43.8.
May I read that? 43, subsection E.
is board meeting.
Board meeting, and then in 8. Subsection E.
8, state government.
The state government and registrar may appoint nominee to the board or any subcommittee of a cooperative society on its own motion when the government have subscribed more than 50% of the paid up share capital or when there is a provision for government nominee in its bylaws. On the day when the arguments were advanced in the writ petition, neither my friend nor I had instruction on that. Subsequently, we brought it to notice. Otherwise, the government has nothing to oppose or take side of the other side.
We just
Only-
want to
only-
highlight, yes, we just want to highlight
Yeah, correct.
these two aspects. One is, your lordship, that 14/9/2023, ARCS has rejected the executive meeting. That is in our affidavit in opposition in the writ petition, your lordship. And thereafter, the hearing report and findings, both these were never challenged by the petition.
But we are not enlarging the scope of the argument. We are only restricting it
So
to 43.
that is my only
Using-
humble submission.
Just now.
Yes.
Where is that affidavit?
Affidavit, your lordship, it said in 6243, your lordship.
No,
The
page.
Page number, your lordship, 87. The letter is dated 14/9/2023. Annexure E, your lordship, page 87. Letter is from ARCS to President, Dibru Dangari. Lordship will kindly read serial number 1, your lordship. Among the 9 numbers of directors, Lordship has it, yes. Among the 9 numbers of directors who were present in the meeting, 3 members are also as co-opted members. So by order dated so and 38/2023 of Registrar of Cooperative Society, there was only 1 vacancy for the post of director. But in the meeting of Board of Directors dated 14/9/23, 3 directors are selected as co-opted members of the Board of Directors. There are no data available in the office regarding absence of said 2 members in 3 meetings of the society. As per the documents and data available in the office, there are no documentary evidence exists that Sri Sanjay Das is currently working as secretary of so-and-so Samabai Samiti as a joint Zonal Registrar of Cooperative Society Jorhat, letter dated 14/7/23. The required action has asked to be taken by the order of Registrar of Cooperative Society Guwahati dated 38/23. So the detailed proceeding dated 14/9/23 submitted by you is not acceptable. So ARCS did not accept the executive meeting. On 14/9 it was communicated because that executive meeting had decided on the AGM dated 39, Your Lordship. This letter was never under challenge in the writ petition.
All these arguments were advanced and thereafter my lord was pleased to pass this order, which is
That's
under
not what
review.
I'm trying to understand because
I am not opening to that part, my lord. I'm only narrowing within the pressings of review.
Thereafter, the hearing report was there, Your Lordship.
just a moment.
Yes, Your Lordship.
Where is this communication of 29/9/2023 referred to in page 25?
I'm afraid in the review petition, we do not have it. Oh, review 9.
Yeah, 9.
Review.
It must be in the writ petition.
My lordships.
If this is referred in the judgment, it should be a part of the
Correct.
writ petition.
But since I was only on the documents for 43/8, my lord. We'll get back with the judgment, my lord. I mean, the file. I leave it to your lordship consideration whether 43/8 has been complied with.
Huh?
I leave it to your lordship consideration 43/8 whether has been complied with. The rest we had argued way back and therefore the judgment had come. He's trying to enlarge the scope of the argument, my lord. That perhaps the review jurisdiction may not be correct. I mean, lose in review.
I just
That's a
want to
little-
clarify.
29/9 is the AGM held.
2 AGMs were held. I'm trying to recall, my lord. 29 and 38. We said 30 is not permissible at all. 29 was valid because you cannot have 2 AGMs for a particular society. To demonstrate that, we had given the chain of events in the timeline, how the secretary and the the chairman and the vice chairman were brought in, how the secretary remained, and until which date he remained, and then those arguments were advanced in detail. And therefore,
No, just a moment. You see, I'm trying to formulate this.
I understand that.
This 29/9, which is referred in page 25, it refers to a communication which is appended to the communication dated 29/9 by ARCS.
I'm extremely sorry, my lord. I have to get back
On
to my file.
29/9,
Yes.
there is also an AGM.
Yes, 29 held by us and 30 by them.
No, I'm just-
29/9 is your
I'm
Lordship.
trying to analyze this page 25. Page 25, there is a reference to communication dated 29/9.
Yes, Your Lordship.
Lordship
That-
will find
It's page 29,
in
Annexure D, Your Lordship.
in WPC
In WPC,
1975.
no, 6243, Your Lordship. 6243, page 29, Annexure D, Your Lordship.
29.
Yes,
So this is a,
this is the forwarding letter through which this, if Your Lordship come to page 30, Your Lordship, that the hearing report and finding was forwarded, Your Lordship. Because there was a direction of this honorable court, Your Lordship, to conduct a hearing. There was one AGM on 29, another on 38.
I could get the facts from the file, but what I could recall is the
So
date
Your
on
Lordship,
which
the hearing.
the other person was declared as the secretary. The notice was issued well prior, where he was continuing.
just
the Lordship, is 29, and then page 30 is a hearing report. Lordship had considered this report, your Lordship.
So here, question number 8.
Yes. The findings are there subsequent to 8.
But this is a case where the board is trying to go for a re-election, regardless of the fact that the 43-8 has been complied with substantially. And they have not challenged the order of my passed by an order in appeal. So that has attained finality. The board is not gone for appeal, my lord. The discussions, the arguments, everything was in detail. The only thing which I came for review is 43-8.
Okay.
Now we are at a stage, your Lordship, where we need to hold the election. We could not hold the election because of the flood situation, your Lordship. Now all we are seeking is 45 days time, and your Lordship, I just wanted to place this aspect, this factual position. So all we are seeking in our IA is a 45 days time, and we'll hold election, and then can both the parties
And
can
what
participate.
I'm
in
on is, my
your
lord,
Lordship.
so far as compliance of 43-8 is concerned, they are admitting it. If they are admitting it, now that's the crux of the matter.
But
43-8 is substantially
yes.
complied. If 43-8 is substantially complied, then Lordship may please to review the order. If that is so, my election comes in. Election held on 29 comes in.
But there,
I'm not even
we
re-arguing the
we
matter.
had forwarded the representations, your Lordship, that we admit, your Lordship, that this
that is
was
there,
3
with the
months prior to the AGM.
Page 25, whether
that's
the compliances has been met. That's all, my lord.
3 months prior to that, but the executive meeting, as well as which held that the executive meeting was not done because there were 3 members were co-opted, whereas there was a vacancy for only 1 director. That aspect, as well as there was no nominee was there, your Lordship, which was held in the findings of the inquiry report. Inquiry report and the letter of ARCS was never challenged in 6243. That is in review, your Lordship. The judgment passed in 6243 is in review now.
What I am on, my lord,
So
is Lordship,
that
the
is
election
my
will pass after
humble
all the arguments and deliberations made. On the touchstone of 43-8, there is admission of that. And the other party who had held the AGM on 38 is not even bothered to challenge it, or not, so they have also accepted it. If 43-8 is complied with, my lord, then I leave it to your Lordship whether or whether not to review the order. I am not again arguing the facts like my friend has started up. We have done that for
I'm
too
just
long.
highlighting the factual position, your Lordship.
That
We
is
have
actually
nothing,
directly
both the
my
parties, they can
respectful
either go to
understanding.
the election within 45 days, your Lordship hold. Or if
Restrict
your
the
Lordship hold
43.
otherwise also, we leave it to your Lordship.
I could have an answer for everything pointed out, but that should not be the review application, my lord.
Another aspect is also there, your lordship, when the, assuming but not admitting, your lordship, the ARCS had come to a erroneous finding, they could have submitted this report subsequent to the hearing report which was published, your lordship. If this letter was there, and this was given 3 months prior to that, they have never placed that.
No, but not placing is one thing,
Yes, yes.
but you see, the effect of this letter of 16.6
Yes.
will be that there was no default on part of this committee, correct?
They have sent the letter. That we admit. It has,
It's okay.
it has been
But
forwarded from here.
what will be the, if this is correct, then what will be the fallout? That means that the holding of the AGM will not be incorrect.
But there is another aspect which is there, and that is why I brought that 14.9 letter, your lordship. Because the hearing report also held that the 14.9, that letter was never challenged. Because the 14.9, the executive meeting was held, co-opting 3 members, and they had, your lordship, that fixing the date on 29th as the date for AGM. So if 14.9 itself is illegal, your lordship, then the subsequent event could not have been a legal proceeding, your lordship.
What my friend is trying to do is he's
And-
trying to reopen the argument again, Milord.
I'm just
I'm
placing
only
the
on 43.
factual, I'm just
So we are
placing the
not even taking the
factual,
factual background.
factual
We
position.
only
your
know whether
lordship.
No, it's okay.
43 is compliant.
You're making submissions.
Yes, I'm making a submission. Your lordship will consider it. We have, they have, the mandate of the act is for to go to the members, your lordship, to a democratic process. Both the parties have been litigating for more than a year, your lord, and lordship had rightly directed to organize, to hold the election, your lordship. Unfortunately, because of the flood situation, we could not hold it, your lordship. All we are seeking is 45 days time, your lordship, and they can go to the members, your lordship.
Okay. If by the time I dictate the order, it will be always, it will be late, so you'll get it only on Monday. Mr. Kalita, you have to say anything?
I am subscribing his submission, Madam.
Okay.
We have knowledge.
One thing he adds on that they have not complied 43. They have not even canvassed that they have complied 43. That's, he's not saying that.
You know, it's ultimately you come into the same boat.
No, we complied. If lordship goes, they did not say they complied. They accepting it.
No, but for that default, you are same, on the same boat.
Not quite. That's by acquiescence. We come in review.
Correct. You're right. At least you have done something. You've been able to demonstrate from that letter,
Lordship.
which is accepted by Mr. Rajkumar.
Lordship.
So if that is complied, one part of the order it comes in your favor. That's it's not illegal for not giving notice to the government. Correct. That's
If-
what you.
if I, now it's over, the argument is over. If I can just be open up. In all fairness, what we are on is not what has gone through our analysis of everyone, but what is the reasoning behind the dismissal. I'll be hitting only that part in review where the reasoning is wrong. He may have a fair call to say a lot many things. I would have answered that in appeal. But here I'm only on that part. And if the reasoning has 2 or 3 more parts, I would demonstrate everything in review. If not, I'll stick to it. Which they have failed to challenge.
We never doubt your ability.
He didn't do it till now.
Still submitting your looks.
I know.
Lord. Okay. If the lordship can be
Friendly.